let's start again with the second panel. And we are lucky to have amongst the panelists Diane Daly, IP attorney at law in Kingston, Jamaica. Good morning, I would say, Diane, as it is very early in Jamaica. We have our very own Natalie Portesi from UV Mona Kingston, and Miss Grace Lindo, another IP attorney at law in Jamaica. So good morning, Grace. And thanks, Grace Diane, for being with us at such an early hours in Kingston. So the second panel is focusing on comparative competitive identity, and we will go through several important areas of IP within the Caribbean with the context of small islands, of course, trademarks, GIs, and then an IP right, an IP asset which we have not mentioned so far today, which is trade secrets and the use of NDAs, non-disclosure agreements, and their interface with competition. Very often, protection of trade secrets may clash with the competition law provisions, especially when employees leave a company to be recruited by another company, of course. And then more broadly, we will look at cross-border challenges within IP regimes. So the first panelist we have on paper is our very own Natalie, and so I am very happy to leave the floor to you. Natalie, we follow the previous scheme, so 20 minutes, more or less 20 minutes each. And then after Natalie, we will proceed with Ms. Grace Lindo and then with Ms. Diana Daly. So you have the floor, Natalie.
Morning again, everyone. Hi, Diane. Hi, Grace. Happy to have you here with us. So today I just wanted to give a Caribbean outlook, quick snapshot of trademarks, GIs, national competitive identity, and how small island states can take advantages of these IP assets and leverage them to increase their economic standing and, of course, innovation in the country more broadly. So when we think about leveraging national competitive identity in IP terms, we're thinking about geographical indications. I don't think in our earlier panel we gave a sort of definitional context for geographical indications. And perhaps the simplest way to explain it would be a good that is produced in a country that is seized of very special properties that it obtains by virtue of being produced in that place, in that country by those persons, and that the quality of that product is somehow emanating from that place. We did hear one or two examples, I think, from Keisha in panel number one. She mentioned Blue Mountain Coffee. She spoke about, I think, Trinidad cocoa, and I think she mentioned something also from Grenada, maybe cocoa as well. And we will consider that as I go along. Traditional knowledge, folklore, traditional cultural expression. Andrea did mention this treaty, which was recently concluded in 2024. And I did mention how Jamaica has already incorporated in its Trademarks Act and its Patents and Design Act some amount of protection for our traditional communities through those pieces of legislation. And the idea of country names and nation branding was raised by Keisha, and is very much something I'm going to delve into in my discussion. And of course, the question of country of origin labeling. Now, in reference to geographical indications, we can think about how Jamaica was very much at the forefront of this in the region. We can think about Jamaica jerk, which was surprisingly the first GI to be registered in Jamaica. Everybody thought it was going to be Blue Mountain Coffee, Jamaica Blue Mountain Coffee, but Jamaica Blue Mountain Coffee actually remains an unregistered GI, recognized as such, but not in fact registered. We can, of course, think of Jamaica rum, a very quickly, very popular GI in Jamaica. And perhaps I will ask Grace at a later date if she would like to tell us a little bit more about that GI. But interestingly, Jamaica rum as a GI is a very clever way of leveraging the country name and the national competitive identity, because the country name Jamaica is included in the GI. And that does have some technical hurdles in terms of registration, because it presupposes that the entire country of Jamaica is capable of supporting the specification to carry the name Jamaica rum. If you recall, the sort of quick explanation I gave is that the place gives the qualities to the product. So presumably, the designation of the place where the rum is made meets Jamaica on a whole. So that's very interesting. We can compare that to Trinidad and Tobago. With their cocoa, the GI that they registered there was Montserrat Hills cocoa. And this seems a little bit more obvious to understand because the cocoa is produced in Montserrat Hills. The designation of the geographical indication is Montserrat Hills cocoa. But my question was, but if you could produce the cocoa in a wider space, could you not have borrowed from the Jamaica rum example and called it Trinidad and Tobago cocoa? What they have done is that they've actually spent quite a bit of time invested in what is known as Trinitario cocoa, which is actually a trademark. So they've used a combination of IP assets to promote their cocoa business. Trinidad has also quite interestingly registered the steel pan. I think this was mentioned by Keisha in her presentation. And that led me to think, well, they must have a number of steel pan makers in Trinidad and perhaps even outside Trinidad. Does it now mean that all the sort of local production now has a hurdle to jump in terms of continuing to make steel pan, which is so widely produced in the country? So in a way, it comes back to what Andrea was saying about balancing creators and users, even at the national level, once that IP asset is created. Here we have an illustration of Jamaica's two foremost traditional groups, the Maroons. On your screen, you're seeing them on the left-hand side in the typical bandana gear, which is the national cloth of Jamaica. And you can see the tradition of blowing the abeng, which is a cow horn. I don't know if you can spot the gentleman blowing it with his mouth. And on the other side, we see perhaps the more popularly known group, which is the Rastafari community, and they are readily identifiable by their long locks. And I think that Rastafari and Jamaica and reggae music, there is a synonymity between these three things that is undeniable. When persons think about Jamaica, they think about Rasta and they think about reggae and its music. So this national identity, national competitive identity, is something that many business entrepreneurs have tried to leverage and to use similarly to almost like a personality rights way. How could we find a popular Rastafarian to promote our business? And Bob Marley was mentioned, because certainly the Marley family, the Bob Marley Foundation, they have used his image, his songs, his everything, his photographs to sell just about everything. In fact, there was a bit of ridicule. I think I've seen once Bob Marley toilet paper. So from very, obvious things like, Marley Rizla, Marley Natural for cannabis products. There's a whole, Sidella Marley has created several clothing lines along the Rastafari theme and colors. So we want to bear in mind that now, at least in Jamaica, with the Trademark Act, there are some administrative hurdles that would protect someone like Bob Marley for persons wanting to use the iconography, but more broadly, the Rastafarian community. So why do country names matter? Well, official names of state are fundamentally distinct. When we think about geographic names, we might ask, why should they be treated differently from country names? And it's primordial. Your country name is your sovereignty. And so I would argue that you should make the distinction between the other kinds of place branding that you see around the place. So you might see Brixton Ale, for example. You will see Tokyo Smoke for a cannabis smoke shop in Canada. And there are a number of other examples where people have used city names in branding. But I argue that country names are very much different and require a very different approach. And this aligns with what we heard from Andre in the first panel. One of the ways in which individual Caribbean states can branch out from being lumped together as simply Caribbean is by using their country name. This will add a level of distinctiveness to their national competitive identity. Admittedly, not all the countries have the same level of recognizability internationally. Jamaica has always, and the economic studies have borne this out, the economists will tell you that the Jamaica brand is easily recognizable, even though it might not necessarily be ranked among a nation brand per se, using an economist measurement. And I could explain that by saying that Swiss is a readily recognizable nation brand. And they're a good comparative to make because Switzerland has in fact ratified several pieces of legislation that cumulatively is referred to as the Swissness regime. And the Swissness regime is a very good model for Jamaica in two ways. Firstly, the legislation explains what a product must establish in order to be labeled Swiss. So Swissness is a concept of being made in Switzerland, made by Swiss persons, and made of Swiss materials. And the legislation actually offers you percentages that you have to respect. It does have some carve-outs. Chocolate is a good example. They carve out cocoa because Switzerland does not produce cocoa. But in order to be labeled Swiss chocolate, all the other ingredients must, of course, come from Switzerland and be made in Switzerland. And we saw a couple of years ago that Toblerone had to, in fact, remove that drawing of the Mont Blanc from the Toblerone packaging because actually it didn't meet the Swissness criteria to bear the label Swiss-made Swiss chocolate. So just as an example. The other way in which I think Swissness provides a good example for small states in the Caribbean is that they have gone about signing individual bilateral agreements with their key trading partners. Jamaica and Switzerland actually does have a bilateral agreement, and it is extremely effective because it's an exchange of lists. We've thrown out the window all the requirements to show that the geographical indication has already been registered locally. We've thrown out any sort of administrative hurdle. We have simply exchanged a list for a list. So whatever is on the Swiss list, Jamaica will protect. Whatever is on Jamaica's list, Switzerland is prepared to protect. And Switzerland has gone about just racking up individual countries, bilateral, that they have gone about exchanging these lists. And I think that's very, very clever because it's very difficult to expect at a macro level that a TRIPS is going to change or a Paris Convention is going to change or any big major trade agreement is going to change. But on a one-to-one, if you have enough of those, you've covered actually your most important trading bloc and the countries that matter. So this is a good example of what I mean about the official name of state and that national competitive identity. We see the made in, well, this chicken sandwich was made in the UK at McDonald's in the UK, and they branded it Jamaican chicken. And let me tell you, it was all hell to pay. They were picketed. They had to get rid of this sandwich. Jamaica was not having it. The second example is actually a chocolate bar that you can find in any supermarket in Jamaica. Bella Boca is actually the trademark. And the I Love Jamaica fine milk chocolate, yeah, man, which is something I guess I don't know how popularly Jamaicans say that, but it's supposed to be hearkening to some Jamaican expression. This chocolate, although sold in Jamaica, is not made in Jamaica. If you flip it over, it says it's made in the EU. And what's more, they actually have included the logo of a Caribbean organization on the back of it. It's really weird because it has nothing to do with Jamaica or the Caribbean. You'll notice the nice Caribbean sea and the red, green, and gold Rastafari harkening boat in the back. Total confusion. And lastly, this one out of America, Pringles with the Jamaican jerk. So this one, maybe a little bit easier if you were thinking of how can I get them to stand up and take notice from a Jamaican perspective, because Jamaica jerk is actually now a registered GI. But as with all intellectual property, it's only as good as your registration in the local jurisdiction. So unless Jamaica jerk is not only registered in the US, but registered in the state where this is being done, and all the ramifications of bringing an action in the US are possible, and you've got the finances to go after Pringles, then you're kind of dead in the water. And the biggest risk, of course, is not so much the financial implication. It is that you run the risk of Jamaica jerk becoming generic. That's the biggest risk. I'll just skip over this slide very quickly, perhaps a bit too technical for 20 minutes, but certainly just to explain that the functionality of the country names is important in the domain of indication of source, also as distinct from an appellation of origin, where you're guaranteeing the geographic place reputation. We have mentioned, of course, the importance for GIs, which is to protect the evocative value of the geographic name. And of course, the recommendation being made that country names deserve a sui generis regime. Again, Jamaica at the forefront of this, because in our Trademark Amendment Act, we do in fact now protect the country name Jamaica, and we also protect the country names of our partner countries. So we're extending the same protection to other country names that we have in fact entrenched for Jamaica. And the use of the country name Jamaica in trademarks is managed by the Jamaica Intellectual Property Office in collaboration with the Prime Minister's Office, and you need permission to include the country name Jamaica in respect to trademarks. And so the national competitive identity function of the country name, you know, I've been asked often, you know, well, how do you prevent people who use it in the US? There's a Jamaica Queens. If you see a Jamaican restaurant, can't you then say that? The bottom line is the use of the country name should simply be not false. Let me not say that it must be true, but it should be not false. So it's good to say Jamaican flavors for a Jamaican restaurant. It's bad to say Cafeteria Jamaica when you're in Spain. This is a Spanish restaurant. They tried to register it. They failed. And it's simply ugly to incorporate the Jamaican iconography and come up with a Rasta beaver with Jamaica Me Crazy. That's really, really ugly. That certainly wouldn't fly in Jamaica, and it shouldn't anywhere else. We can think about how in the music industry, Enrico, this collaboration with Clarks, Jamaica is obsessed with Clarks. We love Clarks. Through the music industry, Clarks and Jamaica is like synonymous with reggae music. But this collaboration is a little bit strange, and certainly now runs afoul of the Trademark Act amendment, because out of many one people is the national motto of Jamaica. Here we see it actually appears in the back of the shoe. And of course, the use of the flag. This would actually be running afoul of the Paris Convention, not just of local law. And this group soldier winning, 22 best Grammy reggae album. I think there was quite an uproar that, it was even possible that a group like Soulja could,
American.
yes, could win. Yeah, they're American. A non-Jamaican could win this. So there's an element too of appropriation or misappropriation of the national competitive identity, and that's a little harder to measure, but it certainly is a threat. We can think about how this is manifested locally. We can see there was an example years ago at the bottom with the nation brand Jamaica on this energy drink. It was a Croatian company tried to register Jamaica as a trademark when Usain Bolt was winning all the races in Beijing and so on. Luckily, through diplomatic channels, that was averted. We can think about with domain names. Not everybody's as lucky as .ai, as we heard with Anguilla. Here, Amazon, the popular marketplace, seemed to have won quite a bit of traction to the detriment, I would say, of the Amazonian countries. We can think about there were several lawsuits with Atout France and France the state. And France the state simply said, look, we own our country name, you're being cancelled, we own France.com, and that's the end of it. I'm not sure the extent to which small nation states might have that sort of clout if we saw a repeat of that. Iceland had a similar brush in case law. Iceland Foods is a popular frozen group, and there was another group, government group, the government of Iceland, through their Inspired by Iceland campaign. They won out in the end, but it was not easily won in terms of the trademark registration of the country name Iceland by this frozen food group. On the other side, two good Swiss examples, this barbecue sauce, the name of the trademark, it's actually a Trinidadian company producing Swiss barbecue sauce. And I've not gone anywhere in the Caribbean and not seen this company. They produce macaroni, they produce a wide range of products, and their trademark is simply Swiss. So it's very strange. And the bottom, we see an example of Belle Swiss. Belle Swiss actually had all of the cantonal flags on display in Belarus in front of this bag. And again, this was resolved through diplomatic channels. And so it's interesting, I think, that we can't give up on the diplomatic side. The public-private partnership route that you spoke about, Andrea, is very important in advancing that. I mentioned this case already, I think, with Toblerone, but have a look at the whole truth. I wanted to just share how much we have advanced with this business of Swiss chocolate. I'm not sure if you can see it really well, but these chocolates now say Madagascar 100% cocoa and Trinidad 80% cocoa. And this is very important because this is exactly what I think the Caribbean needs to be going for. We have to stay away from repeating the mistake that we made with sugar of exporting unbranded raw materials that then go into very high-end products. Now, I don't know if you are able to, can you see it? I don't know if you can see it. This is a chocolate produced by Laderac, one of the premier chocolate makers out of Switzerland. And I've actually seen it, it's in King Cross St. Pancras as well. And it says 80% Trinidad. So this is now the way in which I think Switzerland has been very much proactive in not just their Swissness law, but in showing reciprocity to other countries where they know the raw material is coming from another country, and the use of the country name then becomes very important in buttressing the national competitive identity of Trinidad for cocoa. We see here, Kit Kat tells you that the dark is coming from Ecuador and Ivory Coast. We see, here's actually the photograph in the Laderac store, 70% Ecuador, 64% Madagascar. And I have to say, I tried all three and they do not taste the same. It was the most amazing experience. They're very, very different. And you will see that there are the Swiss bells, which is iconic Switzerland, is these large bells that go around the cows. So the decor of the store, you can't mistake it. You are eating quote unquote Swiss chocolate, but it's not false because they're telling you where the cocoa is coming from. All right. This is what we want to avoid. I'll close with this. Here is a Jamaica flag that I purchased coming in Jamaica before coming to London. And you will see it says made in China. This is what we would like to get away from. But Enrico, I think some of the points you made ring out here. It's that it's so expensive to produce these things in Jamaica that if you have an economic bottom line to meet, the likelihood is that everything in your Jamaica souvenir shop is going to be made somewhere else where it's easier to produce because we just don't produce those things, right? How can we then be proactive about ensuring that there is buy-in locally in Jamaica to use what we do produce and to promote those things and leverage our national competitive identity? I share this slide kind of tongue-in-cheek because I think, in a way, if you begin to re-envision your national competitive identity, everybody will pay attention. And this is a campaign that we've all paid attention to, Making America Great Again, renaming Gulf of Mexico, Gulf of America, is actually, there's some ingenuity to this campaign because what it is saying is that we want to repatriate to the US the manufacture of things made in America, made by Americans, made of American produce. And by leveraging this national competitive identity, by changing the way we trade with people and renegotiating trade agreements, we're hoping that this will innovate the market so that things will be made in the USA and somehow that will redound to a much stronger economy. I'm disassociating myself from anything except for this one clever moment. All right, so thank you.
Thanks so much, Natalie, for this insightful presentation on country names, graphical names.
Oh, sorry, just one more thing I wanted to show quickly.
Yes.
So I have here, can we see it? Oh, let's pick this one. It says National Banana Chips. And I will read what it says, right? On the back, it says, packed for Continental Baking Company, product of Ecuador, right? This is one of our premier Jamaican chip makers. I can show you this one, St. Mary's Banana Chips. Now, St. Mary is a parish in Jamaica, one of 14 parishes in Jamaica, that has been one of the biggest banana producers in Jamaica for a very, very long time. And so when people see St. Mary banana chips, you assume you're buying your good, old, well-known, lovely Jamaican bananas from St. Mary. Must be great. These are product of the Dominican Republic, is what it says on the back. And I will show you one more. These are a favorite here in London. Everybody has tried the ginger biscuit so far. It's a little bit smaller. Not sure how to make it any closer. Why I like this one, National has made this ginger biscuit, right? But it has on the bottom a little sign that says Original Jamaican with the flag of Jamaica. And this is an OG original Jamaican product, made in Jamaica, by Jamaicans, with Jamaican ginger, which we are working towards a GI for ginger. We've got special ginger. There are lots of examples in the UK of products bearing Jamaican ginger that have nothing to do with Jamaica. So what we want to see is the UK product with the Jamaican ginger, but it should tell you on the back, made with Jamaican ginger. Yes, over to you, Enrico.
Thanks so much. I was saying yes. In several jurisdictions, there are rules in place which aim at fighting this phenomenon. For example, in continental Europe, we have unfair competition rules which aim at discouraging entrepreneurs from misleading consumers, because in many of these examples you have shown us, basically there is a direct or indirect aim at confusing consumers by making them believe that a product has been produced in a country when this is not true. Not only unfair competition rules, but also rules on misleading advertising. They overlap this kind of protection, right? In common law jurisdictions, we have a passing off issue. So there are national rules which, if applied correctly, should stop this kind of behaviors in terms of also protecting consumers, not just the entrepreneurs, because consumers deserve to receive correct information, right? So by protecting entrepreneurs who are victim of this, you also protect consumers, right? So, but I would stop here, and I would, if Andrea does not have any, or maybe we can postpone at the end. So I would leave now the floor to our second contributor, panelist, who is, as I said before, Miss Grace Lindo. Grace, thanks for joining us at such an early hours in Jamaica. So you have the floor. Thanks so much.
Thank you. Thank you for having me at such an early hour in Jamaica. I'm glad that we are, you know, in the warm climes here, maybe too warm, albeit early in the morning. And I do think that I have really enjoyed the presentation so far. You know, Natalie, you have brought home, certainly with your visuals, you know, ways in which we in the Caribbean perhaps are being taken advantage of. Before I go on, and I will address this a little bit more, we do have, you know, certainly in Jamaica, we do have laws on misleading advertisement, misleading actions by producers in our jurisdictions. And we'll see how perhaps that's our method of implementing unfair competition laws, certainly in Jamaica. No, it is by no coincidence that I'm wearing yellow today. One, to stay out of, you know, any political phrase, but certainly to do my own type of, you know, country branding. And I'm wearing yellow because during my studies over 10 years ago, I remember a classmate of mine asking, you know, I was in my Jamaican colors at a particular event. And my classmate asked, what is it, my Colombian classmate, what is it that you have done as a country to create a brand with colors? When I see black, green, and gold, I think of Jamaica. And I was like a bit, you know, shocked. Or at least stunned for a minute. I mean, I know that we have created a reputation, but certainly when you see someone outside of Jamaica picking up on the fact that we have created this reputation through marketing or otherwise, or through sport, or through our music, or through, you know, just being Jamaicans, very active internationally, it certainly comes home to me that we are a brand. We carry ourselves as a brand. And certainly if we can leverage that, then it can be to the advantage of our economy, our local economy. And Jamaica is not the only country. You know, we're looking beyond Jamaica today towards the rest of the Caribbean. There are also other Caribbean brands when you think about Carnival, which is not necessarily from the Caribbean, but certainly in the Caribbean jurisdictions who have created this festival sort of branding. Caribbean Carnival or Caribbean Festival just ended a week or so ago in London. And certainly that too has its own side of branding and type of branding, an extension of which is a steel pan, which now is AGI within Trinidad itself, jurisdictionally. Now, the Caribbean is pretty small. So when we think about the competitiveness of the Caribbean, and I want to focus on that aspect of our discussion today, we have to recognize that we can't be the best market for ourselves. We're 7.2 million people in the English-speaking Caribbean and 45.7 million in the wider Caribbean, including Haiti, Cuba, Dominican Republic, which of course are Spanish and French-speaking, and we have some Dutch-speaking neighbors as well. And we certainly, even within that $45 billion region, we can't, be a market to ourselves, particularly because of the level of development of our economies. And so we have to look externally. We have to see how, as small island nations, we can be competitive, whether through being productive or certainly creating products which are considered top-notch products, which attract a certain value because of the branding and because of the work that has gone into creating these sorts of products over the years, whether it's through marketing or otherwise. And, Natalie, and certainly in the first panel, you went into our laws and a bit of how we have tried to do that sort of protection over the years. But when we think of the policies that have come out of, certainly out of Jamaica, and we think of what we consider as national branding, in Jamaica, we have this goal of Vision 2030, which is just 4 years away. And one thing that we have recognized as part of country branding is the importance of Brand Jamaica as a means of communicating our national identity, who we are. Because unless we know how to sell our culture, others will sell it for us. And I think the brands and the counterfeit products, if you want to call it that, which Natalie put up on the screen, really illustrate how others will sell us if we do not learn how to sell ourselves, if we do not learn how to commercialize ourselves. On the national branding hexagon, which I won't take credit for this, but this is by Simon Anhalt, we speak about tourism, exports, governance, investment and immigration, culture and heritage, and people as being crucial to that sort of national branding hexagon. And it's important not to leave people out of branding. We tend to think of the brand being for commercial usage, but a brand is something which inures to the benefits of a commercial undertaking, which provides jobs, which helps the economies in the region. And so we should never forget that people really are at the very foundation of what our brands are. Now, in terms of geographical indications, which is what I'll segue into, because that's perhaps the law which has tried to bring national branding and to bring this sort of brand appropriation under control. And within the region, there have been quite a few GIs which have been developed. And we spoke earlier about Jamaica Jerk, which is the first one, Jamaica Rum, which is now highly, contested. It is something which is before the courts, and I can't speak too much about it, but it's both before the courts and before our competition authority, which I think is very important. And we have other GIs or other attempts to create sort of geographical indications. We have spoken at length during this presentation about Blue Mountain Coffee, which actually is a trademark. They have attempted to create a certification system. And I think they went that route because our geographical indications law had not come into force yet. Our certification system for Jamaican Blue Mountain Coffee has been around for decades, and it operates through the Jamaican Agricultural Regulatory or Commodity Authority, in which they pretty much have worldwide registrations for Blue Mountain Coffee, and they authorize entities to affix the trademark, both the word mark and the logo, on packages containing Blue Mountain Coffee. Has it worked? Perhaps it has. It's a very complicated system and very hard system to maintain. As compared to a GI, there needs to be, of course, constant renewal of the trademark, not only in Jamaica, but in other jurisdictions. And that is maintained at a governmental authority level. And so you can understand that it is difficult to maintain. It is difficult for them to supervise the use of that trademark in over 80 jurisdictions worldwide. But it does exist. Locally, I have heard news, or rather in the news specifically, attempts to register a new GI called castor oil. As you know, castor oil, Jamaican castor oil, has particular medicinal properties, and it's very popular overseas, particularly within the diaspora, the Jamaican diaspora. And so we can look out for both Jamaican ginger and Jamaican castor oil as GIs, which are up and coming. But in other jurisdictions, Natalie mentioned quite a few of other GIs which exist, the Trinidad and Tobago steel pan, the Montserrat Hills cocoa. St. Lucia has, I think, the newest GI on the market, for want of a better terminology. In 2024, St. Lucia promulgated its local GI for St. Lucian rum. Very well written specifications. I think they took a look at how the European Union will particularly accept this GI when it goes to Europe for registration. They give significant thought to the geographic location and the contribution of the geographic location to the maturity of the sugarcane, to the distillation of rum, and otherwise, the human inputs which are important in the creation of a GI. Just to note that a geographical indication can be an agricultural good, but it can be something else. It can be a byproduct, as we can see from rum. In some jurisdictions, such as in India, handicrafts, textiles are GIs. In other jurisdictions, their laws allow even services to be GIs. Brazil, for instance, has a whole tech park, which is a GI. And certainly as a country such as, ours, or a region such as ours dependent on tourism, I do see us moving towards service GIs down the road. But for now, our laws do not accommodate service GIs. All our GIs are goods related. And the goods may be wholly from a jurisdiction, or it may be created with the reputation from the jurisdiction. And that's one distinction between the GI system and any other perhaps type of IPR, which you may have, intellectual property right. When you look on the GI statute, not only our statute, but certainly the Paris Convention, GI laws are to recognize something which exists. It's recognizing a status quo as being important enough to be recognized under the geographical indication law that has been promulgated. And I think that perhaps recognition, or that perhaps distinction, is where we, have created, or where we've seen some contention, certainly locally, as to what the GI laws mean. But that's perhaps a longer discussion for another day. Now, certainly in respect of competition, we do have very small jurisdictions, and the application of competition laws within these small jurisdictions can be problematic. We in the Caribbean, and certainly in Jamaica, we tend to look to competition laws and jurisprudence coming out of New Zealand, and to a lesser extent Australia and Canada, particularly New Zealand, because we want to see how competition works in smaller territories, right? Because if you don't, then you end up applying something which is perhaps applicable in the European Union, 27 jurisdictions now, which may not be wholly, on all fours with what we need in the Caribbean. But certainly we do have competition laws. Quite a few of our jurisdictions have these laws based largely on the same framework which is available worldwide. Abuse of dominant position is something which can be a contravention, as well as any horizontal agreement between parties, which can be considered contrary to good competition in a market. Of course, there are exceptions. If there is an agreement or an abuse which can lead to technical or economic progress, then that can be something that our competition regulator can look to. Or certainly if there is an IPR which is being protected or being enforced, that can be an exception to the laws. Of course, geographical indication laws and GIs are excluded, certainly in Jamaica, from that list of IPRs which are recognized under our competition laws. But we do have areas or jurisdictions which protect unfair competition in various ways. So other jurisdictions have particular specific laws on unfair competition. Jamaica has unfair competition in the sense that the Paris Convention contemplates being translated in its consumer protection laws and its Fair Competition Act, in as much as it speaks to misleading advertising or misleading consumers. And there are people who have taken, action before regulators in respect of such action as it may occur. Overseas, which is perhaps where we need to see action being taken regarding misleading consumers, we have seen where local brands have been subject to such action. In the United States, for instance, a popular Jamaican brand, Red Stripe, was accused of promoting its goods as originating from Jamaica. The Great Jamaican Lager Beer is inscribed underneath the very stripe. But it turned out that the beer was not being produced in Jamaica, and there was perhaps a minority shareholder action on the basis that they were misleading the public as to the origin of the good, which resulted in production being returned to Jamaica largely. And so you see that there are various systems within particular jurisdictions, jurisdiction specific, in which you'll see consumer action. You may not see it within Jamaica. It's very hard for us to police what will happen overseas. But in other jurisdictions in which you have particular minority shareholder action being very large, or you may have in other jurisdictions consumers who feel that they are being misled. If they take action, then certainly we will see movement on that for. But it is something which I agree with Natalie that we may see bilateral agreements, we may see action on the sort of consular level, we may see our government taking action, and perhaps they have the resources to undertake such preventative enforcement, which we as Jamaicans sitting back here in the Caribbean and residing here may not be able to do. So we look forward to seeing that. Before I go on, let me just give you some examples of GIs from the wider Caribbean, because we're larger than the English-speaking Caribbean. Certainly, one more English-speaking Caribbean GI, Demerara Rums, is also a GI, and that's a very unique GI. As opposed to the other GIs we have seen come out of the Caribbean, Demerara Rums comes from the Demerara company itself. So that's a GI which is geographically based, but it comes from the company Demerara. And that's, I think, the first of its kind, certainly in the English-speaking Caribbean. Dominican Republic has quite a few, Cacao Dominicano, Mangos Dominicanos. Of course, you know, the Dominican Republic has a significant agricultural sector. I was amazed when I visited just earlier this year. A few others, Ron Dominicano, Cigarro Dominicano, Cafe Barcelona, and quite a few others, quite an extensive list of GIs coming out of the Dominican Republic. Ron de Cuba is also a significant GI, and we've seen attempts, if not completion of that GI registration within the European Union. Tequila out of Mexico, going to the wider Latin America. Costa Rica, of course, has their Cafe de Costa Rica. Generally, I've seen the increase in perhaps knowledge on the utility of GIs worldwide. You know, when I go to these international conferences or speak to my colleagues, you do see people approaching these GIs and the need to protect nation branding in a greater, a much larger framework than hitherto. And so I do think it's going to be something that we need to watch as it grows, as the awareness of the area grows, as people, begin to utilize GIs much more. Locally, just, at a very surface level, I can indicate that we have before our courts contentious matter concerning Jamaica Rum GI. More importantly for me as an IP lawyer is that there is a complaint regarding this Jamaica Rum GI before our competition authority. And I say it's important because, as you know, within Europe and in other jurisdictions, competition laws have largely grown out of intellectual property-based disputes. We don't have patents here, so you're not going to see the standard essential sort of patent disputes here or the licensing disputes regarding TV rights here per se. But you now have our first IPR-related competition dispute locally, and we're looking forward to see what our competition authority will determine in that matter. It's really an exciting time to be in, whether the competition law area or in the intellectual property area, because finally we're seeing a marriage of both. And certainly when we consider competitiveness, that's where we need to go. We need to develop the jurisprudence on what it means to be competitive regarding our intellectual property rights. Where do I see this area going? I see more government involvement. I do not think that our local manufacturer groups have the resources. And when I say resources, I mean more than economic resources, but human resources to really bring themselves together towards having a cohesive GI for their particular sector. I see not necessarily our regulators, but certainly another aspect of our government to prevent, any instances of conflicts of interest. I see our governments being a bit more involved in driving us through that process. I see us perhaps going into the service recognition of service GIs, as Brazil has done, and perhaps extending it even into handicrafts like India. In terms of threats, supervision of what we register overseas is going to be a challenge for us. It makes no sense to only stop our registration process here locally. The markets overseas beyond our 7.2 million or 45.7 million is where we need to target, both in terms of commercialization, selling, and also enforcement. And, getting those enforcement actions or measures started will be a challenge for us, just economically, and having the wherewithal to do it. So that may be a threat for us. But the bilateral approach, I agree with Natalie, has worked well. There are people in my profession who feel that we should have just gone the bilateral route in relation to GIs, full stop. I think there's a danger there. There is, because of the potential growth in the area in totality, there is a trajectory towards international recognition, or rather a recognition in the way that we now perhaps have for trademarks. And so that trajectory should not be disregarded. But at the same time, we need to look at other jurisdictions to engage those jurisdictions for agreements such as the one that we have with the Swiss right now. Now, before closing, although I've concentrated on GIs and competition generally, I wanted to speak about NDAs and trade secrets. Yes, we don't have laws, statutes in the, well, certainly perhaps not in the English-speaking Caribbean that I know of, certainly not in Jamaica. But there are common laws which will enforce trade secrets. When you think about the employer-employee context and scenario, our new Patent Act, though it may not be the best for our jurisdiction, it does speak to creation of patents in that particular context, entrepreneurial patents in the employer-employee context. And I thought that was important because it provides clarity. I don't think that our copyright law has the level of clarity that the Patent Act has. And certainly I welcomed the addition of clarity in relation to patents or utility models, which our new law recognizes and which may be more applicable to us in Jamaica. There is clarity regarding ownership of such in the employer-employee context. And so that provides a bit of comfort for investors. We're looking to create a brand in which, of course, people are at the foundation, but also businesses are sure as to what the laws are and to how they can assure us to how they can protect their innovations once they invest in the region. So that's important. That's it for me. I know Diane will come with an extensive presentation as well, and we're stressed for time. So that's it for me. I look forward to discussing in the panel discussion thereafter, or in the Q&A discussion thereafter, in the event that you have any questions. Thank you.
Thanks so much, Grace. This is a very, very interesting and complete overview of the most important IP issues, from trade secrets to geographical indications, not just in Jamaica, but in other islands. You mentioned the recent geographical indication protection by St. Lucia on St. Lucia Ram. So it seems there is an ongoing pattern there. Demerara Ram a few months ago, and we await some news on the protection in the EU, right? As EU PDO, EU PGI, that would be a way of boosting exports to one of the richest markets in the world. So I guess there should be more maybe technical assistance in order to help, extending the protection in areas such as the EU or UK, where the market is so important. So thank you so much again, Grace, for this presentation. And now, Diane, thanks for again staying with us at such an early hour. And you have the floor.
Hi, everyone. I say hi because I don't know whether it's morning, noon, or night in your neck of the woods, but
almost after. Almost after.
I am pleased to join the rest of the panelists, and thank you so much, Natalie, for inviting me to participate in this very timely and well thought out workshop. So I do have some PowerPoints to share, so I will just see if I can get that on the screen. So just give me a little moment. So I hope everybody can see my screen.
Yep.
I want to particularly, thank you so much. So I have been tasked to look at cross-border issues and challenges in relation to intellectual property protection. I will do a sort of zoom in on geographical indications, because I believe in the IP ecosystem, I think GIs sort of emerge as particularly complex and nuanced. And we certainly have had a lot of discussion here already concerning GIs. So we do know that the protection and enforcement of IP across borders presents several challenges. And these challenges, I believe, become arguably more complex with respect to GIs, as for the reasons I mentioned earlier, and we will get into it more. I will highlight some of the legal complexities in terms of cross-border IP protection. And as Caribbean enterprises, entrepreneurs, and producers seek to optimize protection of their assets in global markets, this is really a timely issue, as I've said before. Now, I know that with Natalie, you would have already been grounded in robust definitions of intellectual property, GIs. And so for me, it's just making it simple. We know that GIs are linked to origin, reputation, collective identity, and Grace has already given, Grace and Keisha have already given some examples of Caribbean GIs. So my goal is really just to unpack the legal challenges of protecting these rights across borders and to assess how Caribbean legal systems are responding or not responding to these challenges. So we will just do a sort of deep dive on some of these GI specific complexities. What are some of the core legal challenges in cross-border IP protection generally? It's fraught with legal hurdles. The rights are territorial in nature. International frameworks are oftentimes fragmented. National laws vary widely. There are some jurisdictional conflicts and enforcement barriers, which further complicate matters. And these challenges are amplified, in my view, when dealing with GIs, which are inherently collective and culturally embedded. So in terms of jurisdiction specific, we know that enforcement requires registration. I know to protect a GI in Jamaica, you don't really have to have a registration, but obviously, if you're shooting for optimal protection, you will need to register. But this just territorial limitation has had us rely a lot on, as we have mentioned, a bilateral framework and also the international framework. And I think this sort of fragmented protection leaves producers vulnerable to misuse in foreign markets. So in terms of gaps in the international framework, we know that we already have a sort of robust international framework for the protection of GIs. And we know it has been sort of ramped up with the Lisbon Agreement and the Geneva Act. However, there is very little Caribbean participation in these frameworks, apart from the TRIPS Agreement, the Paris Convention, for example, which really doesn't grant full GI protection or doesn't provide a framework for full GI protection. And the EPAs, the Economic Partnership Agreements, we really do not have the level of participation for Caribbean nations as we should. And in fact, international treaties really do not override domestic enforcement mechanisms. And so there's also just this ununiform implementation of protection, and national implementation varies in not just in quality, but in legal approaches. I do a lot with just looking at Caribbean IP laws, not just as a practitioner, but also as a lecturer. And it's very, very critical that you really look at the differences, the nuanced differences in legislation, even though there is a level of harmonization, there are various different approaches. Every island seems to want to bring some particular style and also recognition in their different laws. So even though you might have a trademark law that is pretty standard across the region, you really have to zoom in to see some of those differences. So it's not uniform. And we know already that some countries treat GIs as trademarks. Grace mentioned the Jamaica Blue Mountain coffee as one such example where it's really a certification mark. And some don't have any sort of recognition. Others, like us, Jamaica, adopt a sui generis approach as well. So jurisdictional conflicts can arise when multiple countries might claim authority over an infringement, and that might lead to some sort of forum shopping and inconsistent rulings. So there are some enforcement barriers, and these enforcement barriers are, one, procedural complexity across jurisdictions, high litigation costs, and I should say here, not only enforcement barriers, but barriers to gaining protection in the first place. And I think that's one of the issues that Keisha looked at, just the cost of acquiring protection across borders. It's high for our small jurisdictions. And there is certainly the fact that we rely a lot on our small and medium enterprises, and they lack the capacity for sustained international enforcement. And so those are some of the enforcement barriers. And so just looking at geographical indications, I believe that GIs can be distinguished from all the other members of the IP family by virtue of their collective nature, their authentic ties to a country or region's cultural identity, agricultural peculiarities, depending on whether it's a GI for goods, and other unique characteristics. And so I believe that GIs are particularly vulnerable to misuse across borders due to these particular factors. GIs depend more on collective action and bilateral and regional collaboration rather than the strategic actions of one enterprise when dealing with cross-border issues. Those are just the points that I was making. And sometimes they're often classified as certification or even collective marks. And they definitely require intergovernmental cooperation for effective enforcement. In terms of some legal gaps, in the Caribbean, as I mentioned before, GI protection is a bit inconsistent. I think there is a move towards a progress towards change in that regard. Jamaica, I think, stands out in the English-speaking Caribbean as quite advanced in this regard, but most other Caribbean countries so far rely solely on the trademark system. Bilateral agreements are rare. Jamaica's agreement with Switzerland, of course, is a standout for the region. And there is no harmonized regional protocol. And this weakens collective enforcement. I wanted to highlight this thing about the bilateral approach, and I know Grace just touched on it. The low participation in sort of bilateral agreements. I believe that bilateral agreements, history has shown that they are a necessary part of a robust system of cross-border protection and enforcement, and they are key to successful management of GIs. Under these agreements, bilateral partners generally permit each other to use their respective GIs on specified terms. As Natalie pointed out, an exchange of lists and enforcement is aligned with the rules of the country of origin, and this sort of solves potential conflict of laws issues. We know already that Switzerland has successfully engaged this strategy across regions of the world, including Jamaica. And so for me, too few Caribbean countries are engaged bilaterally. There are some institutional weaknesses, I think, that exacerbate the problem. There is, and institutional capacity is a major barrier. Many countries, for example, lack specialized IP courts, and I'm not saying that you necessarily need a specialized IP court to deal with these matters, but certainly you need a cadre of jurists and just judges that understand the nuances of this area. Also, there's a lack of robust enforcement agencies and streamlined registration systems. Producers are often unaware of GIs or just lack support and resources to register and promote them. And there is also, back to my previous slide, weak interagency coordination. So there are also, as we said before, cost barriers and limited access. Multi-jurisdictional registration, we know, even for trademarks, is prohibitively expensive. And even with a Madrid protocol that has had a positive impact in that regard, it is still hard for SMEs and small groups of producers to really afford protection overseas or in jurisdictions that matter. So there is the lack of legal and financial resources, and this limits the ability to protect these unique kinds of assets. I think Keisha touched on this aspect very well. In terms of policy, I do believe that the Caribbean has experienced different trade policy shocks. One of the main ones, of course, occurred decades ago when the WTO agreement was being sort of reformulated, which shifted, there's a shift in agricultural policy and the end of preferential trade agreements. And that was a major disruption. And but producers are moving more towards value-added goods, which require strong IP protection to succeed internationally. And without legal safeguards, these efforts are really undermined. The other area, I believe, is just, I'm just trying to write, the enforcement and digital challenges. There is weak cross-border enforcement mechanisms, and the digital age has introduced new enforcement challenges. Online platforms enable global distribution of these counterfeit and infringing goods. Emerging technologies like AI and blockchain raise novel legal questions. And so Caribbean legal systems must evolve to address these fast-moving threats. So, and we all know that AI and these emerging technologies are both opportunities and threats, but AI now certainly will just enhance the ability to copy things better and to make things look more legitimate. And so, and I think that's an understatement. And so we really need to ramp up in terms of addressing these sort of digital challenges. So there are some export vulnerabilities as well. Caribbean exports rely on origin link and linked reputation. Counterfeiting abroad undermines brand integrity and economic returns, and legal recourse is often unavailable or impractical. So what are some of the legal solutions? I think we need to refocus on regional harmonization via CARICOM. We know that the EPA has sort of forced this on us, to put it another way. Sui generis legislation, GI legislation across member states. And I think we do need some amount of bilateral engagement in terms of mutual recognition for GI protection and enforcement. Regional collaboration, I think, is something that we really have to focus on more. And also, we know that leveraging the trade agreements that we are a part of as the Caribbean, the EU CARIFORUM EPA, the UK CARIFORUM EPA for GI recognition, we need to sort of leverage those more. And I think also regional IP offices or regional GI registries to centralize registration and enforcement. I know that this has worked well for other regions. Natalie had mentioned Caroso just in the domain of copyright and copyright licensing earlier, and that is certainly something that we look at as a pioneering effort on the part of Jamaica in the area of collective management of copyright. Maybe there is something similar that can be looked at in relation to GIs. Of course, of a different nature, we'd be looking more at a regional registry and also something that would be more manned by government rather than by private enterprises. The public-private partnerships, I know that was mentioned earlier. That is another strategic solution. And this will really aid with legal support and registration funding. Litigation is extremely costly, as we have already said, and also acquiring and maintaining protection is also quite significant. We could also use some digital traceability tools to authenticate origin. So my final thoughts, since I didn't want to go on for long, I know I usually go long. Cross-border IP protection is legally complex and resource intensive. I think we can all agree on that. But it's also a strategic imperative. GIs are, and IP in general, GIs in particular, are more than economic tools. You know, they are expressions of sort of a cultural identity. And so Caribbean legal systems must rise to the challenge by investing in infrastructure some more, by really strategically looking at harmonization and innovation in order to protect and safeguard these unique cultural and economic assets. Protecting our heritage, protecting our cultural identity with not divorced from the whole concept of globalization is very critical for our future. Thank you very much.
Thank you so much, Diana, for this again complete, very clear and interesting presentation. Again, you touched on several interesting issues. One in particular is the use of new technology. Now, you mentioned the blockchain technology, which I also mentioned in my at the beginning this morning. As far as I understand, of course, I am far now from the Caribbean. What I have read, of course, is that the blockchain is already used in several Caribbean countries to help, for example, licensing, right? To help distribution of royalties, tracing use of music. I wonder, what is the state of the art? How much is it used? Of course, there are rooms for improvements, but is it at the beginning? It's, as far as you know, artists use directly or indirectly this technology. How is it helpful to them? What is the state of the art? If you are aware of that? Yeah.
Well, for me, I will probably throw that to others because I know it's used. I know it's been used more in the creative industry side. And I don't know I don't know the extent to which it has been successful, but certainly it would be interesting to see how it can apply to other forms of intellectual property rights. But certainly in the creative industries, they have been trailblazers in using these kinds of technologies to advance protection and authentication as well. But I don't know if my other colleagues have any other examples to put forward.
Of
Right.
course, Grace, if you are aware of, some specific uses, how much it is used, the extent it is used. Yeah.
Right. So it has, it's an excellent question. And let me just say that tracing is going to be, one of the ways in which we should minimize the cost of enforcement. But it is used in relation to Blue Mountain Coffee. There was a project which started the use of the blockchain technology in tracing the authenticity of Blue Mountain Coffee. It has been discontinued just under a year since start of use because the cost of it is prohibitive for farmers. So that's the balance that we have to think about. I mean, these two new technologies are useful, smart contracts, blockchain. And certainly in the long run, we have to move in that direction. But it was proving very costly, which means we have to seek an investment, whether it's from government or some other way in which we have someone covering the cost. Because the latest news coming out of that test case or use case was that it just was not financially feasible.
Interesting. Okay, I would now extend the discussion. Andrea, if you have something to say also on the previous presentations by Natalie, then Grace and Diane. Don't think so. We have touched so many issues.
Sit beside me.
Interesting.
Actually, if it's good, yeah, just sit beside me.
Okay.
Well, first of all, I would like to thank all the speakers because it was really fascinating. And I have one remark and then one question for all of you. And the remark is that from the very beginning we said, every country must find its own form of intellectual property, and it's always fascinating to see how, for instance, a tool like geographical indications is interpreted, because of course, I come from continental Europe. I have a model in mind, and then I work with, let's say, South American countries, and I see that some concepts are interpreted in a different way, and then maybe the Caribbean, it's also slightly different depending on what the country wants to achieve, and this is really fascinating. I just have a very general question about geographical indications, but we could go beyond that. We can talk about collective marks. We can talk about certification marks, for instance, state-owned certification mark. They exist. There is a slight problem I see, and I'm looking at you, Natalie, because you are here with me, but of course everyone is. For instance, you took the example of Switzerland. And I think that the two cases, Jamaica and Switzerland, are very different for a simple reason, that Switzerland is a country that takes stuff, for instance, chocolate, for the nation branding. Instead, I have the impression that Jamaica is per se a small island in the Caribbean, and then it has an heritage, a culture, a legacy, if you want, which is way, more bigger. And this is problematic, I think, when it comes to nation branding and in general to GIs, et cetera, because they will tend to be state-centric. So I make you an example. A large part of Jamaican heritage is ripped off just by people who want to make money out of it. I see a lot of, if you want, post-colonial way of thinking here, like saying, Jamaican culture belongs to everyone because, Jamaican can't be the owners of anything. There is a lot. But I see there is also a different kind of problem, which emerges a lot in geographical indication. For instance, I presume that there are honest communities of Jamaican origin in the United Kingdom, in the US, and they want to live in the Jamaican way. They feel part of the Jamaican culture as much as they feel part of UK culture or US culture. And so I think you see where I am going. So state-centric branding system, let's talk about geographical indications, for instance, could maybe be potentially harmful because you cut off variants and stories that, because Jamaican culture is much bigger than Jamaica as a jurisdiction, could be in fact totally honest and worthy of attention. Unfair competition is a different story because it's an ex post kind of protection. So it's case by case, and you will see case by case, this is passing off, this is not passing off. With geographical indication, we have seen cases of honest variants, stories, developments, which have been cut off because the idea is, because of course, GI sometimes a bit arbitrarily, they select an area of production. So I don't know if in your thoughts, this potential danger has ever come to your mind, in your reflections.
No, I have to say I dispel it completely. Unfortunately, I only had 20 minutes, so I didn't go too deeply in the famous case of Cadbury and the Swiss chocolate manufacturers as an example. I want to agree with you about each national competitive identity coming into its own, separate from the broader Caribbean identity. Grace, you raised the example of the Notting Hill Carnival. And it was interesting because it was my first time actually really immersing myself in the carnival this year, for several days. And I searched the carnival all 3 days for doubles. Doubles is a traditional Trinidadian dish, which is absolutely delicious. It's split peas and curry with a kind of bread, a light bread, which they call doubles, actually, but it's a kind of roti or bread. And in fact, almost every single stall that I saw, I was there Saturday, Sunday, Monday. I couldn't find any Trinidadian food on offer. Every single food vendor that I saw was selling curry goat, jerk chicken, rice and peas, kalalo, ripe plants, these ackee and saltfish. These are all traditional Jamaican gastronomic delights, right? Gastronomy delights. So it was interesting because the carnival was divided into very large trucks playing music primarily from Trinidad, but from also other countries in the Caribbean that have this type of carnival music, soca or calypso, and revelers dressed in costumes. And this is in the Trinidad tradition, and other islands in the region have this carnival tradition of masquerade and soca music. And then in other places in the location of the carnival, which is spread out across the Notting Hill area, Portobello Road and so on, you then come across Channel One. Channel One is the signature rockers, Jamaican reggae music spot. And there are lots of other places around, little pockets of Jamaican music where people stay around those sound systems listening to Jamaican music or Jamaican derived music. So there was another setup for drum and bass, which is the evolution of Jamaican rockers here in London. And drum and bass is a London classic, right? But just to say that as you went along, you saw all these Caribbean people, everybody with their own flags, everybody was showing their flags. But when it came down to the food, it was all Jamaican food. So it's interesting. I disagree with you, Andrea, because I think I want to speak a little bit to what I will call the coloniality of intellectual property. And it's a thorny issue because some of what we claim in the Caribbean is an advanced, evolved, derived version of something that our forefathers brought. And it didn't just come from the colonial master, it also came from the persons who were brought here as slaves. And there's an evolution in how what we now value as IP assets and want to classify as Jamaican or classify as Trinidadian and so on. And it speaks to what you also mentioned, Diane, in terms of the conflicts. And I can give a very specific GI example. When I think about Havana Club and Havana, the rum coming out of Cuba, the family that had the Havana Club GI, when they moved away from Cuba to another Caribbean island, there was then a conflict within the family of who should then control the GI. What strikes me as interesting as well is that there are so many GIs that include the country name. And that's important. That's something that I think we can have a much deeper look into why that choice was made, as opposed to a Montserrat Hills. We're talking about, you know, GIs that include the country name. The second example I will mention is the internal conflict, Diane, that can happen when you have cross-border. It's an internal cross-border where Jamaica Rums is perhaps, I don't know what the controlling share is, Grace, you don't have to comment, but Campari, which is an Italian company, has a significant shareholding in Jamaica Rums. So when we begin to talk about where the direction of the GI Jamaica Rum should go, you kind of want to ask yourself the question, is this an internal conflict for the broader brand Jamaica and what perhaps, you know, spirits pools and other Jamaica rum interest might have in the outcome of the debate that you mentioned, Grace? So conflicts are not just cross-border. Sometimes they can very much be internal. And the other comment I wanted to make is about the drawback of registering the country name as a trademark, because then the country name becomes subject to all the vulnerabilities that every other trademark is subject to. You could become generic. You could have your country name become generic. You could even possibly see the country name as a trademark fall off the register if somebody forgets to renew the registration. So there are definitely weights and balances to be had in the debate.
I wanted to add an element which we have not mentioned, which is important, the Jamaican diaspora, right?
Yes.
Because when there are more Jamaicans or first, second, third generation abroad than in Jamaica itself. In London, UK, Canada, US, the other countries. So it's quite inevitable to see Jamaican-inspired products popping in markets such as US, Canada, UK, because, you know, these are maybe also produced by or inspired or encouraged by Jamaican communities in other countries. So a few years ago, I made a research on the effect of migration on geographical indications, right? For example, European, Italian, Spanish, going to America, Australia, and bringing with them the names of their cities or their regions. The same probably happened with many Jamaicans leaving the country decades ago.
But do you know, Enrico, when I started my research on country names, I discovered that the country name that is most registered is Italy in relation to food groups in particular. It is Italy. And my argument is not that there should be a monopolization on the country name, but it should be a public good that is managed so that it does not become false. It should not be false. So if a Jamaican family starts a Jamaican restaurant in Brixton, I take no issue with that. I take issue with someone who puts the country name Jamaica on an energy drink in Croatia. I have an issue with that because it also has the effect, harkening back to what you brought up, Andrea, of dilution. Because then you actually begin to hollow out the national competitive value of the country name Jamaica for what it can potentially bring and leverage innovatively for the market. That's a problem. I mentioned the word coloniality from this respect because you suggested, Andrea, that Jamaica and Switzerland is chalk and cheese. Absolute rubbish. when we were having the discussion at the WIPO level on Article 6 term, whether or not to include indicia of sovereignty, country names as an indicia of sovereignty, there was a proposal to include country names. This discussion took place when most of the countries that are now countries did not exist. They were all colonies. So we did not have a seat at the table. It was a non-issue. And so basically what we have seen since country names were left off 6 term is an explosion of new countries and new states and new country names that did not previously exist. So really what we're talking about is first world countries with advanced IP systems and registration systems in particular, who have gone ahead and registered country names of now independent states, and they are struggling to regain their competitive identity. So there was a point where Togo was registered for cocoa, and pretty much that's all they register, but they didn't own it. This is a problem. I mentioned, although not strictly speaking, a country name, Amazon. It's an interesting example to look at what took place with Amazon, because they will never 100% regain the level of control that would be desirable for them to have over the use of Amazon, right? And I could multiply the examples. So the idea that Switzerland is special has actually been rebuffed in the United States. They have accepted it to some extent and rebuffed it in others. So yes, they have a national protection regime, but the USPTO has said, we accept that Swiss for watches has always been special. So the Swissness, the antecedent of the Swissness law was the Swiss watch regulations. It really started with watches, but they refused to do it for other things. And so we have seen the dominoes fall in Switzerland for Swiss cheese and the fight over Gruyere, and there are a number of other Swiss examples where they were not so lucky. But the USPTO has said, we're going to give you a Swiss watch. We're not going to, we agree. Everybody loves a good Swiss watch. But there is almost a bit of an ego around what it means to be Swiss. And people want to lift the word Swiss and put it on a Swiss jerk barbecue sauce. It's a little bit crazy, right? Made in Trinidad.
Just to give more clarifications to our audience, you mentioned Article 6 of the Paris Convention, which I say for the benefits of those who are not very expert on Paris Convention, which protects flags, other state emblems, as well as official signs and hallmarks, international organization, but country names are not included. Natalie gave us one of the reasons why, because it was negotiated, it was drafted when many countries were still under colonial rule, right? But I think, yes, it makes sense what you said, that we need to prevent unfair attempts of capitalizing on other countries' heritage by appropriating their name, but there must be a limit.
National competitive identity. I'm being very specific.
Yeah. Yes, but we need also to, in my opinion, leave free entrepreneurs to use the name of a country which is not his own country, if such use is not unfair, right?
If it's not false.
False in that it leads consumers to believe that the product comes. So basically,
There must be a connection.
misleading consumers.
There must be a connection.
But think of a group of music lovers of Jamaica music, and they want to register something which is contains the term Jamaica, because that's what they do. They collect records. They have a blog on Jamaica music. So we need to make sure that these fair uses of country names could be done without being accused, without being sued, right? But yes, you respond by saying competitive. How do you say?
National competitive identity. It should not undermine the country's national competitive identity. That's what I'm saying.
A too broad concept?
No, I don't think so at all. I don't. I'm not convinced of that, because for too long, I think there has been a reaping of benefits where people did not sow. And we're now in a space where we must not only recognize protection of countries in a post-colonial era, we now must also imagine a space where new countries could emerge, and that's a reality. We can even think about Swaziland, who changed their country name because it was often mistaken for Switzerland, right? So new countries, new country names could in fact emerge. And I won't get into current politics, but it's clearly quite possible that, yes, it's national general elections for Jamaica, but I wasn't thinking about that. I was thinking about bigger geopolitical issues on the world stage where new states could emerge and new official names of states could emerge.
Let me conclude because we are already late. Let me conclude with another provocative comment. You mentioned, and you showed us before, a reggae band from US.
Yes,
white
Soldier.
people, Soldier.
There is a band called Jamaica, by the way, that does pop, and the name of the reggae band is Jamaica,
But
a US band.
you know, Natalie, that there are many reggae bands from America, Europe, UK, even of white people that do great music. Why should we prevent them from incorporating the term Jamaican music in any kind of communication, right?
That was never my suggestion. My suggestion is that if you are going to include the country name Jamaica in your trademarks, in your branding, it should not be false.
As a brand use.
Yes.
But not, of course, as a way of describing what you do.
I have
which
no
is
objection.
playing
I have
Jamaican
no objection with anything that is descriptive. This is perfectly synonymous with existing IP norms. So even if I take cases of champagne, Andrea, you will agree with me on this one, the champagne cases are borne out. If you have X amount of percentage in champagne in your ice cream, you are allowed to say sorbet champagne, right? I don't know about I think the one with the champagne and the body wash or something, they were a bit less successful. But certainly if you had truthfully champagne in your ice cream, then there was some leeway. Right?
Depends on the quote.
It also depends on the quantity. So in other words, it must not be false. Yeah.
Okay, we could go on and on, but I think
Yes, we're out of
I
time.
think
Maybe some
time.
final comments from our.
Some final comments from our online speakers.
I think Grace raised her.
Yes.
Grace, yes.
This was a while ago.
And also from the audience, we have 16 participants there.
Right. I had a brief comment regarding the Jamaican diaspora. I thought that was an excellent question asked by you. We do see quite a bit, I wouldn't say of the infringements, but the attempted use or the evocation of the country brand or of local geographic areas. So people will have, for instance, cockpit country jerk sauce out of Australia, and you find that that's a member of the diaspora trying to evoke home and create an evocation in relation to those trading names or trademarks if they do get them. To counter that, I think we have to be inclusive of our diaspora, which is why I do think eventually we'll have to move towards more reputation GIs and work with our diaspora in getting them to be part of that system and work with them to, perhaps ensuring that if it's an agricultural good, there is some origin or there's some connection to the jurisdiction. We have a very important diaspora. 4 million Jamaicans live overseas. That's the latest count. 3 million people live in Jamaica. And it's really an untapped area in terms of bringing them in to the IPR regime and letting them recognize that sometimes their attempts of creating a connection really weakens brand Jamaica more than strengthens it. So I thought that was an excellent question because we are in a unique situation, not only in Jamaica, but the wider Caribbean, in which we have a very strong diaspora. And while we are trying to prevent uses which may be considered anti-brand Jamaica, we have to see where we can work with our diaspora. Ismail.
May I just say something? I mean, I'm speaking definitely, can you hear me?
Yeah.
Yeah. So I think I'm speaking definitely from a non-IP background, but extremely interested research-wise into coloniality of things. And I would definitely agree with Grace here that one thing, you know, it's about being inclusive of the diaspora, but also inclusive of experiences. So for example, thinking of Libya, which was definitely under some form of Italian colonial rule, they have very much spaghetti and pasta as part of their national dishes. So it's also about kind of recognizing those power dynamics where you have certain
there are certain power dynamics there that should also be included, historical experiences. Or from the Middle East, for example, we have hummus, which is very much something that is debated and upon across the Arab region. But then hummus, it's a region-wide thing that is not probably part of a particular national identity. It's a region-wide. So thank you so much for this discussion. I think especially for those of us who do not come from an IP background, I think it kind of poses questions, more broader questions about economic sovereignty, the limits of economic sovereignty through IP as a tool as well. And I would hope that we have more of these discussions in the future, and more of those colonial and power dynamics that come as well. So I'm just going to use this, actually, I'm going to use this opportunity to close the session a bit. But also, could I please ask the panel members who are joining us online to just appear on the screen, and those of us who are here in person to just gather around the screen for a screenshot or a picture, so that we can post. And again, thank you so much for this event. It was amazing, very much informative. Thank you. Thank you.